everyone. On behalf of Modak Academy, I warmly welcome you all to today's International Webinar. I am Pritili Modak and it is my pleasure to be your host for this insightful session. Today's topic is Gender and Dharma Part 2. Women's Economic Rights in Manusamhita. This important discussion explores the economic rights of women as reflected in Manusamhita, encouraging a deeper understanding of its historical, social, and philosophical dimension. We are truly honored to have with us our esteemed speaker, Dr. Papia Mitra. She is an associate professor in the Department of English at Surendranath College for Women. Dr. Mitra has also earned a graduate diploma in arts with specialization in academic studies of religion from Victoria University, New Zealand. In addition, she served as the president of the Tagore Gandhi Institute for Culture Studies. With her rich academic background in literature, religion, culture, and interreligious studies, Dr. Mitra brings a unique and insightful perspective to today's discussion. We're confident that her lecture will inspire us to think deeply about the intersection of gender, tradition, and human values in contemporary society. Without any further delay, I warmly invite Dr. Papia Mitra to deliver today's lecture. Thank you.
Thank you for the beautiful introduction. Now, good evening, everyone. Today is the auspicious occasion of Guru Purnima, when we pay homage to Gurus who dispel darkness and bring light of understanding. Though I am not a Guru as such, still, this is a serendipitous occasion to discuss about Monu, who is the primal lawgiver, and we can consider him as a kind of Guru for human society as well. The title of my discussion today is Manusamhitaye Nari Sampottir Odhikar, or Economic Rights for Women in Manu's Law Code. In a previous lecture, I took up one of the most hotly debated topics in Indology: how does Sanatana Dharma treat the vexed question of gender? Others have, of course, also spoken of it, but I decided to focus on Manu, since when most of the feminists speak of women in Hinduism, they seem unable to go beyond calling any opposing camp as Monobadis. So, as this is a continuation of the previous talk, I would like to recapitulate my main points there. First, there is not one single Manusamhita or Manusmriti that we can regard as authentic and complete. There might have been an original Manava Dharma Shastra, though it is doubtful if it was written down at first. It is also interesting that according to our cosmology, each age is supposedly ruled by a Manu, and we are currently in the age of Vaishyavata Manu. We can speculate that in the dawn of known history, Manu was perhaps a title given to the first rulers or judges of mankind who set down laws for the civilization that was yet forming. Whatever it might be, the text of Manusamhita we have today is a compilation from various manuscripts and commentaries, demonstrating that it has undergone changes through time and by region. We have both northern and southern recensions, and there are some differences in wordings as well as in the numbering of the verses. In other words, what we read today as Manusamhita, it has not one single author but several, which explains contradictions we find inside the text. Historians believe that the current text reached its final form sometime between the 2nd century BCE and the early centuries of the Common Era. It is nearly 2000 years old. That is why I tried to examine the text as a whole rather than through a few isolated verses that are quoted by both critics and defenders. Secondly, it should be emphasized that Manu's code of laws was not a rigid religio-legalistic system that was blindly followed by monarchs. It was instead treated more as a reference text. Though the antiquity and emphasis placed on Manusamhita is not in doubt, yet through thousands of years, Bharatvarsha have produced so many legal systems that competed with each other. In Hindu society itself, laws and social norms were shaped by a combination of religious scriptures, smritis, customs, regional practices, family traditions, royal decrees, and the principles of the age. Therefore, Hindu society in practice never followed Monu alone. It was the British who popularized it as the primary law code of Hindus while shaping Hindu legal system. Because brought up in the monotheistic Christian tradition, they sought to find an exact parallel of the books of law in the Bible. The Bible is the only source of holy law. Now, since Monu Hinduism was regarded as the first law given, they clung to the Manusmriti as the sole source of the actual law prevailing in India. Mind you, among themselves also there were scholars who protested, but overall, the government is what the government does. Thus, I would say the British made the text a subject of controversy, of love and hate, depending on the outlook of the reader. Our educated class, unfortunately, adopted this very habit. As a result, a massive cultural war is now being waged over Monu. And we know that even now, people frequently burn Manusamhita and call names like Monubadi, down with Monubadi and all that. Third, while many comments about patriarchal regulations of Indian society from ancient days is warranted, there is also massive misunderstanding over how things worked in those times. Sometimes the misinformation is deliberate to incite disgust over regressive Hinduism. And sometimes the assumption is, especially among the younger generations, that ancient society was exactly like modern society. So why did it not function as contemporary society does? They should simply do not understand the historical background. Most people, whether critics or defenders, do not seem to have actually read the whole text or how the traditional schools regarded the verses or take historical context into consideration. Because remember, the latest version we have, that is 2000 years old, and there were a whole lot of commentaries and other shastras after that based on it. And while the Monu Samhita text itself was forming, surely there were discussions and more tikas or bhashyas on it. Okay, I will just repeat an example I have given before. That how certain verses are somewhat twisted. A famous verse declares, Pita rakkhati kaumare, bharta rakkhati jaubane, rakkhanti sthobire putra, na stri shatantra mahati. The father rakkhati, that is, protects her in childhood. The husband protects her in youth. The sons protect her in old age. A woman is not fit for shatantra. Now, depending on the English translation, there is often confusion. Rakkhati is often translated in an English text as guardianship. But if we look at the plain meaning of the word rakkhati, and after all, let us remember, Sanskrit is related to many other languages in India. Rakkhati everywhere, rokha. It simply means protection. Now there is the word shatantra. The term shatantra has been translated as independence. This has naturally led to another controversy that a woman should not be independent. However, in this case, the debate centers on the word rakkhati. It simply means, as I have stressed before, protection or safeguarding. In other words, women should always remain under the protection of their male relatives. Of course, such protection can often turn into control. but that does not appear to be the primary intention here. According to the commentator Medhatiti, Rokkhati is used here not in the sense of guardianship, but in the sense of protection and maintenance. He draws an important distinction, arguing that Swatantra and Raksha are not the same thing. In his view, the verse does not mean a woman may not act independently in any matter. Here, protection means averting danger or misfortune. Danger refers to the suffering caused by such things as deviation from the path of proper conduct, any physical injuries, or the unlawful seizure of a woman's property. Averting means preventing such harm. This duty should be performed by the father and other relatives to ensure that no woman is humiliated or harmed. It means only that she is considered unable to protect herself because she lacks the physical strength necessary to do so. Later commentators followed in his footsteps. The female should be guarded by her male relatives from insults, sexual assault, and physical dangers. To be lacking swatantra or independence here simply means a woman should not be abandoned in a dangerous situation without a protector. All agree that the present passage does not prescribe that a woman must lack independence in every matter. Now, this does not mean that Monu, any version of the writer, was a feminist in the modern sense of the term. I am using this simply as an example of how most of the terrible verses are not actually as terrible as they are made out to be. The text belongs to a society that had a patriarchal framework. So while women were given rights, Monu regarded males as natural protectors. Now the question becomes, if Manusamhita is relevant today? The answer is yes. Just an example. In the modern era, the law has declared women and men equal. The philosophical basis for this can also be found in Manu. Dividing his own body into two, the Lord became male in one half and female in the other. Through that female, he begot Biraj. Thus, call him Brahman or Mahadevi or Lord, it became male and female equally. Here, there is no qualitative difference between women and men. Rather, they are two equal halves of the same primordial being. Thus, we can see here that there is no inequality or hierarchy in the creation of women and men. They are equal. Therefore, granting equal rights to women and men under modern Hindu law does not violate the Manusmriti or render it invalid, as many critics would have us believe. Okay, now let us take a look if any economic rights were given to women in the text. Control over property, over economic resources have always been the source of power in any society. So what resources a woman is allowed to control and under what condition tells us a lot about how the sacred lawgivers in ancient India regarded women. মানে যেটাতে ধর্মশাস্ত্রতে নারীর সম্পত্তিতে কি আইনগত অধিকার ছিল, এইটা কিন্তু খুবই আমাদের পক্ষেতে জানা দরকার যদি আমরা আমাদের অতীতকে জানতে চাই. But again, before diving into property rights, we must understand how property was regarded in an age when extended family was at the center of society, than individuals enjoying citizen rights as it is today. In Manusmriti, property is not merely a matter of personal enjoyment. Wealth is connected with the continuity of family, religious rites, ancestral Shraddha ceremonies, raising of children, hospitality toward guests, and social status. This does not mean that an individual is not allowed to acquire personal wealth or use it as is his fate. After all, artha or livelihood for a comfortable life is one of the purusharthas or objectives of life. This acquisition of wealth, of course, must always be according to the rules of Dharma, Monu himself says the 7 dharmic modes of gaining property are inheritance, profit, which includes storing buried treasure, receiving a gift, purchase, conquest. Now, in the matter of conquest, though obviously this is usually something that is reserved for kings and warriors who go to battle, the commentator Nandana interprets this as winning a lawsuit in court. Then prayaga, that is investment, karmajaga, productive occupation like crafts, trade and agriculture, and shatpratigraha, that is receiving a proper gift from a worthy person. The Shastras also allow various means of livelihood, teaching someone, serving someone, raising cattle, doing business, doing agriculture, and even begging. These are common to all people, especially during times of distress. And that includes all castes, or rather, as the proper Indian term would be, jati. The commentators agree that wealth should be accumulated primarily for maintaining oneself and one's family and for performing obligatory duties, not merely for pleasure. But what about a woman's right to wealth and earning? Within the typical social system we have, the male, particularly the son, is the principal bearer of property and religious duties. The son inherits his father's property, performs the shraddha, and continues the lineage. A woman generally leaves her paternal home upon marriage and enters her husband's household. She is from that point onward regarded as a permanent member of our husband's lineage. That is why, as we have already discussed, Manusamhita declares that a woman in various stages of life should be protected by male relatives. Conceiving of a woman as a protected person implies it is the duty of male relatives to ensure her food, clothing, shelter, and social security. A father cannot abandon his daughter, a husband his wife, nor a son his widowed mother. However, this social conception is also one of the principal reasons for restricting a woman's ordinary inheritance rights, especially as regards to land owned by her parental or marital family. Even nowadays, we find this conception operating in many conservative households, especially in rural areas. This does not, of course, mean that she is completely deprived of wealth or independent earnings. তা প্রথমেতে আমাদের তো একটু ভাবতে হবে যে গৃহবধূ হিসেবেতে গৃহস্থ অর্থনীতিতে বাস্তব ভূমিকা কি। মনু বলছেন স্বামী স্ত্রীকে সম্পদ সংগ্রহ ও সংরক্ষণ, তা ব্যয় করার কাজে, পরিচ্ছন্নতা রক্ষায়, ধর্মীয় কর্তব্যে, অন্ন প্রস্তুতিতে এবং গৃহস্থালীর দ্রব্য সামগ্রীর তত্ত্বাবধানে নিযুক্ত করবে। The husband shall entrust the wife with the task of acquiring and preserving wealth, managing expenditures, maintaining cleanliness, performing religious duties, preparing food, and supervising household goods. Now, there is certain Sanskrit phrase in the sloka, Arthasya Sangrahe Bai, that is collection and expenditure of funds. It demonstrates that the wife's role in day-to-day management of the household economy was acknowledged. All commentators agree that a wife should be entrusted with the task of receiving, counting, and safeguarding the family's money and assets, as well as determining spending as needed. However, managing finances and having economic independence are not the same thing. Commentators also agree on the restrictions. Fund acquisition refers to the safeguarding of wealth, while expenditure refers to its utilization according to household needs. But this does not mean that she possesses ownership over household property. The husband appoints her to manage financial affairs. The woman is the economic manager of the household, but the ultimate authority over the family's property remains in the hands of the male head of the household. So does this mean a woman cannot hold any property of her own? That is a misconception. Traditional Hindu law recognizes a concept called Stridhan, or property of a woman. অধ্যাগ্নি, অধ্যাবাহনিক, প্রীতিবশত প্রদত্ত সম্পদ এবং ভাই, মাতা ও পিতার কাছ হতে প্রাপ্ত সম্পদ, এই 6 প্রকারকে স্ত্রীধন বলা হয়। We have here 6 categories of stridhan. Stri, woman, dhana, wealth. So this is specifically wealth belonging to the woman wholly, which is legally a separate category of property from other types of property. The property given before the nuptial fire, that is called Odhagni. Property given at the bridal procession, that is called Odhyabahanika. And property given out of affection, property received from a brother, mother or father. These 6 types are called Stridhana. As you see, Odhagni refers to property that is given to the bride while the marriage is going on before the fire. Ornaments, money, clothing, or valuable articles presented to her for her own use during the ceremony fall within this category. Adhyata Bahanika refers to property given when the bride is taken from her father's house to her husband's house. It could serve as economic support for the newly married woman's new life, including ornaments, household goods, vehicles, cattle, or money. Priti Datta means a gift given out of affection. Commentators differ regarding the precise scope of this category. For some, this refers to anything the husband gives to his wife out of love or on some special occasion. Others say that the donors also include parents-in-laws or another relative. The other 3 sources of gifts are the woman's brother, mother, and father. Property given to her by her natal family, either before or after marriage, also constitutes Stridhan. Some later Smritikars have called this type of property Shaudika, that a woman's economic connection with her natal family is not completely severed after marriage. This classification sets aside the view that women have no rights to property except maintenance. Now, these items are supposed to be the wife's exclusive property over which she had total control. She could sell them, donate them, or use them as she wanted without requiring anyone's permission. However, this concept of Stridhan, that a wife owns, clearly have evolved over time into the dowry system known today. Instead of granting the new bride rights over her resources, her in-laws would appropriate them all and demand even more. Unfortunately, the daughter's parents, due to our present social system, often view their daughter as a burden to be somehow offloaded, and the grandeur of her wedding to be a marker of social status. Consequently, they willingly handed over huge dowries to the in-laws and tried to give more afterwards. But both families ignored what Manu says. যে আত্মীয়রা মোহবশত নারীর সম্পদ, নারীর যানবাহন অথবা বস্ত্রের ওপর নির্ভর করে জীবিকা নির্বাহ করে, সেই পাপীরা অধোগতি লাভ করে। The relatives who depend on a woman's wealth, uses a woman's vehicles and mounts or her clothes, and their livelihood is derived from her wealth, those are sinners who will go to hell. Commentators explain that relatives here includes husband, in-laws, parents, brothers, brothers-in-law, and sons also. Later Smritikars elaborated that over such goods, and especially the Sauvadika, that is, that which is given by the parental family, the ownership of the woman is absolute, and she is free to sell it or give it away, even when it consists of immovable property. While she is alive, neither her husband, nor her sons, nor her brother-in-law, nor her husband's kinsmen have any rights over her Stridhan. If they take it from her, they should be punished and be forced to return it with a fine. There was also debate over whether the expression 6 types excludes any other types of wealth. Commentators and other Smritis maintained that the number only meant not fewer than 6. Traditional legal systems have therefore emphasized that the number 6 is meant to preclude a lesser, not a larger number. Therefore, additional forms of stridhana, like other gifts from relatives and property acquired from various other sources, are not excluded. This is buttressed by Monu's next verse. বিবাহের পর প্রাপ্ত অন্নাধেয় সম্পদ এবং প্রীত স্বামীর দ্বারা প্রদত্ত সম্পদ, স্বামী জীবিত থাকা অবস্থায় স্ত্রী মারা গেলে সেই সম্পদ তার সন্তানদের হবে। Therefore, 2 more types of stridhan can be gained after marriage. One is anadhya, that is wealth gained by her after marriage. Commentators explain that is property or jewelry gifted to her by any relatives. And the other is anything the husband gifts to her. The verse, that is, Prito Shamik Dara Prodatta Sampad. Anything the husband gifts to her, being pleased with her, that becomes a stridhan. The verse further emphasizes that these 2 types of stridhans can be inherited only by her children. Even if her husband is alive, during her death, he cannot get a share. Though most legal commentators accepted this as another form of stridhan, the commentator Sarbogo-Narayan argues that there is a distinction between stridhan proper and this type of property. It lies in the fact that in the case of stridhan proper, a woman possesses the right to gift or sell the assets, whereas regarding this second category of property, she does not enjoy such independent rights. But he agrees that even those 2 types of assets do not strictly constitute stridhan. If the wife passes away while her husband is still alive, they will belong solely to her children. Now, this matter of inheritance strengthens the woman's claim of absolute right to her property. The husband is not considered to be his wife's natural heir. Her properties are owned to be passed on only to her children. Only if there is no child can the husband inherit. Significantly, even if the assets might have come from him originally, he cannot claim any right to them. You see, this is simply not a view from the past. It is relevant today because contemporary Hindu law also focuses on those stridhan. Section 14 in the Hindu Succession Act 1956, while mentioning other categories of property, declares a woman has complete ownership over her stridhan. It is not limited, as many husbands and in-laws seem to think. This classical framework is further enshrined in judgments. A woman can manage her stridhan, can alienate it by sale or gift, and it devolves naturally on her daughters as successors. Many families are, however, today unaware of this because they mix up stridhan with the concept of dowry, which is illegal. Countless Indian women have their jewelry and gifts they received before, during, and after marriage absorbed by their in-laws as family property, something that the latter can use for themselves and even withhold from the bride. The wife may be accustomed to thinking that everything she has belongs to her new family and not herself personally, as she is now a member of that family unit. And that goes for the in-laws also, because that is how traditionally the marriage is looked upon. They do not realize that both Shastric and current law states she has distinct ownership over such goods. Stridhan can never become joint family property. Similarly, the husband has no title to this property. In 2024, the Supreme Court ruled that such property is the wife's alone, including the ornaments the husband has given her. Though it is difficult to prove that personal ornament or gifts were given to the wife, personal gifts, as they are informal, the courts should rely on preponderance of probability. Even if they are taken by the in-laws for whatever reason, the husband and in-laws are mere custodians. Their obligation to return the property never expires, even upon divorce. Upon divorce, the Stridhon remain her son. Similarly, in March 2026, the Allahabad High Court declared that a husband who takes his wife's ornaments must restore them. The husband cannot file a retaliatory case of stealing against a wife for taking out her own Stridhon, which consisted of jewelry in this case, from the family custody, that is the family safe. The Madras High Court in June 2026 decreed that handing jewelry to a mother-in-law for safekeeping is not a transfer of ownership and directed a husband to return listed jewels within 4 weeks or pay their value with interest. It is important for married women to know these rights because this is also a link between the future, the present, and the past. However, then we might say that scripturally speaking, we run into a problem. Monu also states in a verse, ভার্যা পুত্র এবং দাস এই তিনজনকেই অধন বলা হয়, তারা যা কিছু অর্জন করে তারা যার অধীন সেই ব্যক্তিরই সেই ধন. That a wife, son, and a slave, they are called অধন or without wealth. Whatever they earn belongs to their master. Now, taken literally, the verse appears to mean that a wife cannot own any property. But this obviously ignores the right to Stridhon. Medhatiti directly addresses this apparent contradiction. He asks, if a woman has no property rights at all, how can husband and wife jointly perform religious duties? What is the meaning of the injunction that a husband should not disregard his wife in matters of dharma or wealth? How then can the rules concerning Stridhana or a woman's own gifts operate? He argues that a literal interpretation would render many other scriptural provisions meaningless. Once the existence of Stridhana is acknowledged, this verse cannot be read as a rule depriving women of property rights. So he proposes a qualified interpretation. The woman is not devoid of ownership. Rather, it means her husband's approval is needed for spending. The verse is primarily intended to express this dependence. According to Kuloka Bhatta, who is a Bengali commentator, by the way, the concept of adhan does not abolish the Stridhan recognized in other professions. Stridhan is established by a specific scriptural rule. Therefore, a general rule of dependence cannot override. Raghavananda and Nandana adopt the strictest interpretation. As long as the husband is alive, the wife have no right to spend even her own property without his permission, because she is not independent while the husband is living. If, however, the husband is no longer alive, her complete ownership of her own property is recognized. Now, obviously, here society is being quite repressive towards women, insisting that the husband is the guardian and the guardian of her wealth. Now, as for a woman earning money by her own labor or contributing to household work, just as today a man's earnings are recognized as proper property, whereas a woman's domestic labor is treated as a duty. Although a woman contributes to the prosperity of the family, formal ownership of its wealth remains vested in the male lineage. However, later Smriti authors and commentators extensively debated whether a woman's earnings from crafts or personal skills constituted Stridhan. While some held that earnings acquired by a woman during marriage remained under her husband's control, others included such earnings within Stridhan. And quite obviously, the various Smritikars and the commentators were being influenced by the age they were living in, by the social system of the particular region they were living in. Now, the matter becomes further complicated when the notion of family property versus the personal property comes. Monu states, নারীরা পারিবারিক সম্পদ থেকে অথবা পরিবারের ভরণ পোষণের জন্য নির্দিষ্ট সম্পদ থেকে, যাতে বহু ব্যক্তির অংশ বা অধিকার রয়েছে, পৃথকভাবে কোনো অর্থ আহরণ ব্যক্তিগত ব্যয় বা সঞ্চয় করবেন, এমনকি স্বামীর অনুমতি ছাড়া নিজস্ব সম্পদ থেকেও তা করবেন না। Women should not independently withdraw any money for personal expenditure or savings from family property or from assets set aside for the family's maintenance, in which several persons have a share or interest. They should not do so, even from their own property without their husband's permission. Now, plainly, such an injunction restricts the wife's economic freedom and keeps her dependent on her husband. But the matter is not as simple as it seems. Commentators agree that what is meant is that a wife or other women of the family should not separately save money for jewels, ornaments, and similar items out of joint family property shared by brothers and other members. Nor may they make such savings out of the husband's separate property without his permission. Thus, a woman cannot independently accumulate money from family assets belonging or connected with her husband, sons, and other relatives. Notice the emphasis: joint family property. Nandana makes the point even clearer. The first refers to the husband's property that is earmarked for the maintenance of the family. Now, one modern objections can be that a husband's earnings is part of shared marital assets, and the wife has a right to at least half of it. But again, in ancient India, husband-wife pair is a part of a larger family unit. Even just in our grandfather's generations, I think we had Akannoborti Poribar. The money earned for that family is for everyone to use, just not the wives alone. Again, why is this relevant today? In modern age also, the law has the category of joint family or co-personary property, in which every co-personer, that is someone who is born into that family, has a shared right and joint possession. It includes property acquired by family members using ancestral property or its income. Now, previously, only the eldest male could be Korta or head of a co-personary family. But today, due to reforms, the role is gender neutral. If the daughter is the most senior in age, then she becomes the Korta with all its rights. And the rights include to divide the property among the other family members, to divide the income, and to spend as she thinks fit for the good of the family. However, neither today nor in the past, this idea of joint family property impacted Stridhan. Ancient commentators had emphasized that money accumulated in this manner, that is earned by the husband, or wealth that is part of family assets, cannot be regarded as Stridhan, because that is the exclusive property of the woman. The husband, brother, or any other relative does not become the owner of such property or claim use of it merely because of the family relationship. The property was given specifically to the woman. Thus, the 6 types of Stridhan, they give a special right of ownership, which limits the scope of the general rule of dependence. Now, let me hammer it in, since many people I have found do not seem to understand the distinction. Stridhan does not merge with the husband's general property. Though the husband is the head of the household, he does not automatically acquire ownership of his wife's separate property. He cannot appropriate it for his personal use without her consent. And even then, he has to return it. Now, Katyayana in the later ages states this even more emphatically. During a woman's lifetime, her husband, son, brother-in-law, or any of her husband relatives has no right to her wealth. Anyone who takes it, even with permission, must return it with interest and also pay a fine. This reflects the legal evolution of the concept of Stridhan. Now, property received from the husband and a wife shared in her husband's general property is not the same thing. Only if the husband specifically gives the wife land, money, or ornaments, this becomes a stridhan. But marriage by itself does not make the wife owner of half of all her husband's property. Now we have discussed Saudakya before, property given affectionately by the woman's father, mother, brother, or relatives from either family. The distinctive feature here is the donor's intention. The property is not given for the household's common use or to assist the husband. It is given to the woman personally for her own spending. The husband or in-laws therefore cannot claim ownership merely on basis of their relationship. This principle profoundly influenced later Hindu jurisprudence and on the rights of women to sell or gift her property. Now we must understand that in the Sanatana worldview, the family is an organized economic unit in which the husband is the head. The wife and children are members of that unit. If they acquire property through the family's resources and arrangements, it remains under the control of the household head. A gift specifically made to the wife is a stridhan. The notion of protection is not permission to take, steal, or appropriate a woman's property. Now, most examples of stridhan concern ornaments, clothing, money, and easily transportable goods. Ornaments were especially important as they had practical importance. They could be carried and concealed, and in times of distress, they could be sold or placed to raise money. In many rural areas, this is also true, that the ornaments are the economic security. That is why Monu decrees, the heirs shall not divide the ornaments owned by women while their husband is alive. Those who divide them become fallen. Because these ornaments are meant for the woman's use and it is not a part of general family property. Commentators agree that the heirs cannot take away ornaments from the wife if she had personally possessed and used them for a long time. In this particular instance, the woman's actual possession received legal protection. So too in modern age, courts presume that a woman's customary jewelry is part of her exclusive property, even if there are no receipts for their purchase. This raises the question, could a woman own land, a house, or other immovable property? The brief provisions of Manusmriti do not directly answer the question. Later, commentators and Smriti authors disagreed about a woman's authority over immovable property. According to others, she should not transfer immovable property except for family necessity. According to others, the woman could freely sell or gift land and houses. Now, this disagreement arose from the importance of family-based system of landholding. Ornaments were objects of personal use, whereas land formed the basis of lineages, production, livelihood, and economic stability. Since a woman moved to another family upon marriage, there was a possibility that land belonging to one lineage would pass with her into another. Similarly, it is stated that a widow must be maintained. If there is a son, the property devolves upon him, while the widowed mother has a right to maintenance and residence in the family home. But her rights do not extend to ownership of her husband's entire estate. Other later Smritis do state, if a man dies without a son, then his widow will get the whole of his estate. But in practice, we do not know how this worked out. Now, another verse in Monu states that after the mother's death, her sons and daughters by the same mother shall divide her property equally. Thus, here we have equality between daughters and sons recognized. And also, this creates a recognized line of transmission from woman to woman, from mother to daughter. The father's property is divided after his death and the mother's property after hers. The survival of one parent does not prevent the division of the other parent's property. This rule provides strong evidence for the separate legal existence of women's property. If the mother could possess no property at all, there would be no question of her sons and daughters dividing it equally after her death. It is therefore impossible to interpret the word adhan or without wealth as a meaning a complete absence of ownership. Manusmriti also states that whatever Jautuk property the mother possesses shall belong exclusively to the unmarried daughter, and the daughter's son shall inherit the entire property of a man who has no son. Now, commentators differ regarding the meaning of the term Jautuk. For some, Jautuk is Stridhan. For others, it is property that a woman receives from her maternal family alone. Again, some people argue that it refers to money. It includes also the money that a woman saves from the sums given to her by her husband for clothing, ornaments, and the household's daily expenses. Whatever it might be, at any rate, it goes to the mother's Kumari daughter, that is unmarried daughter. However, one commentator, Sarvogya Narayan, interestingly argues that the term Kumari refers not only to an unmarried daughter, but also a daughter who has no son of her own. Thus, in his interpretation, the daughter's sonlessness is more important than her marital status. You see, this way of thinking, an unmarried daughter has no husband to look after her, while a sonless married daughter has no son to look after her in old age. Both interpretations are thinking of a woman being dependent on a man for her economic security. Now, in this case, I would like to point out that these legalists are not misogynistic. They are actually being human, since they are thinking earnestly about a female's economic and social well-being. But due to the time period they lived in, they cannot get out of the male-centric framework in their minds. At the same time, this ruling establishes a background for property passing from woman to woman. Now, in the case of father's property, the limitations due to patriarchal-centered family become more obvious. The inheritance provisions of Manusmriti require brothers to allot a share of the property to their unmarried sister. Each brother is expected to contribute a specified fraction of his own share toward her marriage and establishment, providing this share is a compulsory religious duty of the heirs. If the brothers fail to give their sister what is due to her, their division of the property is not morally or religiously valid. But they are not given an equal share or any immovable property, only what is enough to get a good marriage. Now, defenders of Manusmriti quote a statement that where he says that just as a son is one's own self, so too is a daughter equal to a son. পুত্র যেমন নিজের দেহ আত্ম থেকে মানে নিজের আত্মজ, কন্যাও হচ্ছে আত্মজা, নিজের দেহ থেকেই দুজনের জন্ম। তাহলে কন্যা যখন রয়েছে তখন অন্য কেউ কি করে সম্পত্তি লাভ করবে? When a daughter is present, how can anyone else inherit the property? Read in isolation, this may appear to be a declaration of equal inheritance rights for men and women. The context of the verse, however, is the putrika or appointed daughter. A sonless father may appoint his daughter to the position of son or marry her off on the condition that a son born to her will perpetuate his maternal grandfather's lineage, carry the maternal grandfather's family name, perform his shraddha or funeral rites, and inherit his property. Here, the daughter functions as a substitute for a son. Manu, of course, states that the appointed daughter herself and no other heir shall inherit the property of her sonless father. All commentators agree no other male relative may claim the property of a sonless man when such a daughter is present. Manu further states that if a son is born after a daughter has been appointed as a putrika, the property shall be divided equally between them. Thus, under special circumstances, the daughter's inheritance is not merely symbolic. In the actual division of property, she receives a share equal to that of a son. Her right is connected to her performance of the duties associated with perpetuating her father's lineage and fulfilling his religious obligations. Okay, now problem with this verse, a daughter is not equal to a son under all circumstances. The verse concerns a daughter appointed as a putrika to perpetuate her father's lineage. It therefore does not establish a universal principle of gender equality, since it is actually about sonship. On the positive side, the Dharma Shastras could, when necessary, recognize a daughter as the principal bearer of both property and family name. Within its patriarchal structure, it thus developed a flexible arrangement for female inheritance. Now, this verse, this practice of putrika, you see, this demonstrates that gender is a social construct. The daughter is assigned the same rights and duties as a son. She becomes a son socially and legally. Socially a son, remember that, but remains biologically female. That is very interesting. Now we are looking at property. In analyzing property rights, it is necessary to distinguish between three questions. First, who owns the property? Second, who enjoys possession of the property and the income derived from it? Third, who has the authority to sell, gift, mortgage, or transfer the property? While the Manusmriti acknowledges the woman's ownership, the question of actual possession nevertheless remains important. Even if ornaments or land legally belong to the wife, her formal or scripturally recognized ownership may be ineffective when the husband or his family controls them. We have seen this again, time and again. Dharma Shastra may declare a proprietary right and condemn the forcible seizure of a woman's property. But social and judicial power is necessary to enforce that right. This was true in the olden ages, and it is also true now. I will end my discourse today on the property with another verse. While the mother, এটাতে কি বলছেন যে যখন মায়ের দুই পুত্র জীবিত আছে, এক পুত্র হচ্ছে প্রথম স্বামীর এবং আর এক পুত্র হচ্ছে পৌর্ণভব, মানে দ্বিতীয় স্বামীর পুত্র, তাদের মধ্যে যদি সম্পত্তি নিয়ে বিবাদ হয়, তাহলে মাতা প্রত্যেকের ঔরসজাত পিতার সম্পত্তি পুত্রদেরকে দেবে। While the mother is still alive, if a dispute over property arises between a son by her first husband and a Paunarbhava son, that is a son born of a second marriage, she shall ensure that each son shall receive only the property that belongs to his own biological father. Here we see that a woman has the freedom to remarry and also exercise considerable control over property, enabling her to determine what each heir would receive. And of course, there is always a Sridhar. In modern age, Hindu laws have been successively reformed to make it gender neutral. Certainly, right now, women enjoy greater inheritance rights and property rights than in the past. But this is not a gift we acquired solely from the West. The seeds of it lay within our own heritage. To put it in Manu's words, যে অর্থ ও কাম ধর্ম বর্জিত, সেই অর্থ ও কাম পরিত্যাগ করবে। আবার যে ধর্মাচরণের পরিণাম দুঃখজনক বা লোক নিন্দিত, তাও পরিত্যাগ করবে। The property and work that is without dharma, we should abandon them. But it is the next line that is most interesting. That if that which is a source of dharma, that which we practice as a religious practice, if the end result is suffering for anyone, and if it is condemned by the public, then even though it is considered to be a dharmic ruling, that must be abandoned. Legal interpreters agree. They have agreed throughout the ages. If a religious practice, or rather we should say dharma, any dharmic practice becomes harmful, then it must be abandoned. Some dharmic rules were permissible in the previous age, but is condemned by the public now or is deemed inappropriate in the Kali Yuga, then that dharmic law must change. So thus we progress, following our own tradition. Thank you everyone for patiently listening.